I'm Suzanne Holland, and I am on the AI and Human Values initiative team that planned the conference, and I also teach bioethics here at University of Puget Sound. So this session is Blurred Boundaries, Bodies, Brains, and Identities. We'll see what that means. And I'd like to introduce, we're gonna have our three panelists, and then we'll have questions at the end, if that's okay with everybody. So if you find you have a question or something you want to talk about, make a note on your pad, and we'll come to that at the end. And we will moderate the questions just as we did the first time. Justin will bring a mic around, and then our panelists will answer from the mics here. So I'd like to introduce Dr. Jennifer King, who is the Privacy and Data Policy Fellow at Stanford University Institute for Human-Centered AI. Today she will take on what we know about how AI may predict information about us, particularly from our interactions with chatbots, so following on nicely on the last session, and from her recently released policy brief on the privacy risks from foundation models. Jen?
Okay, can you hear me? Let me move this. Okay, great. Thanks. I'm going to go very quickly, and so if you have questions, we'll take it during the Q&A session, just to make sure there's time for all of us. But I'm going to walk through, just at a broad level, like why should we care about privacy in the context of AI chatbots? How does the design of these systems really blur these contextual boundaries? Meaning, when I think about a work context or a school context, what's happening that potentially kind of blurs the information I might disclose in one context versus the other? And then more specifically, how these systems are using our personal data, at least to the extent that we know anything about that right now, because we actually don't know a whole lot. But let me start, and actually I don't think we've really talked today yet about what do we mean by privacy? So let me actually just ask you all for a second. When I say data privacy, and I'm talking about chatbot privacy, what does that mean to any of you? Does anybody want to shout out a suggestion? Okay. Oh, you're thinking like the tool is personally responding to you as an individual. Mm-hmm. Sure, so you're thinking about what you're disclosing, essentially. Mm-hmm. Great. Okay, we can get into that in the Q&A. Anybody else want to suggest, when I say privacy, what comes to your mind? What do you think we're talking about here today? Yeah. Okay, so data that you're disclosing, how it might be used by these systems in other ways. I'll take the last, you said a comment too. Okay, great. Yeah, I think there's no wrong answer, to be clear. But I think it's helpful for saying, what do we mean when we're talking about privacy here, and especially data privacy? So I assume that everybody in here has probably had some interaction with an AI chatbot. And if not, we can talk about that too later. But just to say, why does this matter right now? Well, first, because there are literally hundreds of millions of people using large language model powered chatbots. And again, if you've used these things, you may also have this sense that unlike, say, a Google search, where you get, the interfaces actually don't look all that different. You get this empty text box that you're asked to type something into unless you're using a voice version. But what we find is that back and forth really creates this dynamic where people disclose a lot of personal information. And that's not even in the context, like Ryan mentioned earlier, with Replica, where you have this human avatar that's really trying to kind of put an actual face on the conversation. People are disclosing an immense amount of details to just this open text box. There's not even a face on it necessarily. So I will say, I'm going to go over a little bit of the research I've done recently just to say there's a huge lack of transparency around how these systems are taking that data and how they're using it for training purposes. There's some research, not by me, but other colleagues, that demonstrates that models do memorize data and in fact have been able to, other researchers have been able to perturb these models and get them to regurgitate personal data that's been memorized by them. And so the bottom line to me is, so if we're going to use these tools, and that data is then used to train these tools for the future, how can we be sure that this personal information is not being kind of recycled through them or increasingly used to target us? Same way that we're used to right now, we do a search online. We search for the Hawaiian vacation. We get the ads for the Hawaiian vacation into infinity, and that type of targeting that we see throughout the internet ecosystem. And so, oh, sorry, I did this on a Mac, and obviously it's not lining up perfectly, but we don't know a ton about how people are using chatbots right now. The different frontier model companies have been releasing their own research. This is from a Washington Post article from November 2025. I mean, it's not rocket science. Like, we have, I think, a decent sense of how people are chatting with chatbots. But this was an interesting analysis because, and this is something we've seen with a few of these providers, there are ways to share your private chats and have them be posted publicly. So this study was a crawl of the Wayback Machine where they found 40,000+ of these chats that had been posted online and did the analysis that way. So I'd say it's a little bit more objective than when an Anthropic or OpenAI is publishing these stats themselves. So, unsurprisingly, we see at the top that most people are using these a lot like search tools. They're looking for specific information. And then you see other things like, helping, getting writing assistance, coding, and so on. Something like 10% of the data that the Post reviewed demonstrated that people were using these things with these very emotional connections, so not just pure information seeking, but there's emotional tone to the conversations they're having. It's unclear that the people who shared those chats actually knew they were sharing them, because there's been some evidence that in other instances that people have shared online chats and literally had no idea that they had done it. So there was a lot of personal data disclosed in the chats that the Post reviewed. Just as a side note, I'm not talking a lot about chat sycophancy today, but Ryan mentioned a little bit, and I think it'll most likely come up throughout the day. The researchers here found that in general, the chatbot agreed with people about 10 times more than they ever disagreed with them. And that is a really interesting design decision that I think has huge implications that cascade through the system. In terms of these things, always just like, of course, you're the smartest. That's the best idea. Like, it's very different from getting information from an online search, for example. So actually, before I move on, I don't know if you guys can see, these are just examples that the Post pulled out of some of the responses that they found. You can see some of these are really over the top in terms of the either the sycophancy, the emotional content, or just this idea of trying to lead people on that, like, yes, I'm an all-knowledgeable knowing power. Okay. So I did a study this last fall where I was looking very closely at the privacy policies of the 6 major chatbot platforms. And I was trying to really understand from a consumer point of view, this was not a legal analysis, whether the inputs that people were providing were being used for training, what other sources of data were being used to train large language models, and then fundamentally, can you opt out of that if you don't want this to happen? And so I and a group of students looked at OpenAI, Anthropic's Claude, Amazon Nova, Microsoft Copilot, Meta AI, and Google Gemini as the 6 model developers that we looked through. And so we were very much focused on consumer-facing products. Again, this was a facial analysis, meaning that a privacy policy is something that you all should be able to read without a law degree, in theory. In fact, that's really not true, but in theory, it isn't. And you can say, I've never read a privacy policy, you will not be alone. But we developed a coding schema based on both the California Consumer Privacy Act as well as the GDPR. We went through those policies, we manually coded them. For 6 companies, we ended up with 28 documents. And I just want to say that's notable because in theory, everything you should know should be in the privacy policy. That's not how it's working. You have to basically hunt around these sites to try to find all the information to answer just these basic questions. So I'm going to run through my findings pretty quickly. Basically, everybody's training on your data by default. That wasn't the case when we started. Anthropic was the last holdout. They changed right as I was literally putting the last touches on the paper. Luckily, I was able to capture that. So all the providers are using your data for training by default. The exception is if you're paying, if you're an enterprise customer. So if you're a paid client, you get privacy. If you are a free customer, you don't. There are some exceptions. OpenAI's paid consumer product, still used for training. So it's really enterprise contracts, yes, everybody else, no. There are a couple instances, Meta in particular, that does not appear to allow people to opt out at all. So it's like there's no choice. They are going to use it and you don't get a say. Whether you upload your medical records, this is a really common thing people are doing right now. I've been asked by several reporters about this behavior. Pictures, documents, hey, ChatGPT, help me rewrite this paper. Whether those things are used for model training depends on the provider. It's inconsistent. Some do, some don't. Only Microsoft actually was kind of the best actor, so yay Washington. Microsoft actually was very specific on the things they do use and don't use. And in fact, I think went so far as proactively saying they took out people's email addresses, they blur photos, just to say those things are possible. Like you can do that, and the fact that a lot of model providers either aren't, or at least aren't clear about what they're doing, I think is kind of a black eye. Okay, in terms of data retention, in general, there are many cases where they seem to retain your data indefinitely, i.e. forever. This again varies, it's not completely concrete. In most cases, it seems like they are trying to edge towards deleting data in a 5+ year period, but still they're hanging on to it for a very long time. In contrast, Google used to hang on to people's data forever. Like all of your search histories, up until about, I think it was 2018, if you went into Google Takeout, which is their search history tool, you would see everything you had ever searched for up until, really ever. So I think I probably created a Google account in like 2004. Like everything is there. They switched that off around 2018 and put the default period to 18 months, just to give you kind of a comparison. Google's only keeping those things now as a default for 18 months. In many cases, it's 5 years or even greater. In many cases, people are reviewing your chats. Not all. Obviously, there's many more chats than there are humans. But there are absolutely cases where people are reviewing them both because somebody has flagged it saying this was the wrong response, and they do have humans. It's human reinforced back learning, where they want people to actually look at these responses and kind of check them for quality purposes. But we also know that there are lots of cases where people have not flagged chats and that human reviewers are looking at them. There have been a couple of interesting pieces by journalists that have dug into this. And generally it's offshore, so it's workers in Kenya, workers in the Philippines who are getting access to this data. In general, children's data is, whether it's used for training, is kind of a mixed bag. The companies, of course, often say you're not supposed to use this if you're under 18, but they are not currently age gating it or otherwise trying to keep kids proactively off these sites. Some of the platforms do have policies where they allow children to use these tools, and in those cases, they are often not training on children's data. You have to opt in if you actually want them to do that. I don't know who does that, quite honestly. As a parent, I'm like, no way. But again, we know that children are most likely getting kind of brought up in this whole thing because of the inconsistent policies. In terms of what they're doing with the data when you disclose personal data in your chats, we think, there's no regulation here, there's no best practice, so our best kind of assumption is that we hope they are doing things like removing emails, removing your cell phone numbers, social security numbers, things that people might be disclosing in chats. But we don't know, and part of the findings from this project was that it's not being disclosed. We cannot tell. And so some of that's because the model developers have disclosed things in model cards, which is a very specific form of documentation and not necessarily privacy policies. But the bottom line is, as you look at the privacy policies, you cannot tell from provider to provider whether they are proactively trying to take some of this data out of this entire stream right now. It's really a black box. Increasingly, we're seeing use of something called long-term personalization. what this really means is kind of a mix from provider to provider to provider, but the idea of like, I can tell the chatbot, yes, I am female and I live in the Bay Area, and please remember I have 2 kids. All those types of preferences that people set. Yes, the companies are increasingly allowing you to do this. How they treat that data, if they store it kind of separately from other data, like again, we have no idea right now. We really don't understand externally kind of how that data is being managed and so on. And then so just to sum up, from this work, my kind of key takeaway here was that there's a lot of information here, but it's not enough. Like we really today don't have a good sense of what the companies are doing. It's unclear to consumers kind of how their data is being treated. And we really, again, don't know, for example, if I do upload my medical records, so again, people do this, are they using those things for training? Like, we don't know. Since we put the paper out, we've seen a couple companies, ChatGPT, OpenAI, ChatGPT, and Anthropic start to release these specific contexts, called medical contexts, I think to address this problem. And of course, the lawyers in the room can also weigh in on whether laws like the CCPA forced their hand, because you have to treat people's disclosed or collected sensitive personal information or health data differently than other types of data. To me, this was also validation that this research was kind of identifying this problem, that yes, when you're disclosing things in this chatbot context, there are definitely areas where that sensitive data most likely needs to be treated differently. So that's why we are seeing them roll out medical contexts right now, our health contexts. I would like to see others. I mean, I would also argue that we should be able to, not talk to them and have our data being trained on by default, but that's like my privacy researcher pipe dream. And again, this really, to go back to the theme of this panel, like this really does blur the boundaries between, am I using it for work? Am I using it for my home stuff? Am I talking about my personal life? In some ways, from my human-computer design background, I would say I don't want to have to think about that and like create a different context every time I talk to one of these things. But then we have this issue of how do I pull these different streams of data out and ensure it all doesn't go into one giant pot and is used for future training. And again, the question of whether I can opt in or opt out. In many cases, you can't. You are forcibly opted in. You can with Gemini, with ChatGPT and Anthropic say, hey, I don't want you to train on my data, but then you got to dive into settings and find those settings and turn them off. And I have another project that I'm working on right now. It's amazing doing user research with chatbot users, and I'm surprised how many people actually don't go into the settings at all, which I think speaks to the ease of use of these tools. You can just start typing, but a lot of them were completely unaware that there were settings in there that they could turn these types of things off. And then finally, just it's in terms of the boundaries here, LLMs are going to be leaky, meaning that something I disclose in one context can potentially come back to haunt me in another. And we just, again, don't know specifically how to make those boundaries solid right now. And I would say right now they're as permeable as they can possibly be. And then, of course, if you are keeping this data potentially forever or even 5+ years, there are really inherent risks to doing that, certainly from potential hackers. And again, the lawyers in the room would probably give you a whole laundry list of concerns about civil and criminal litigation, and especially even government surveillance. And we know that's happening. We know that the companies have been, especially in the last 6 months, have gotten tons of subpoenas regarding people's chat use, particularly around immigration raids and such. So this is happening right now. And so when people are disclosing months, years worth of data to these machines and not having it disappear, that's all a footprint that even if it's not publicly available, can be privately available to the people who can get access to it. Okay, I'm going to stop there and happy to take your questions when we get to the panel discussion. Thank you.
Thank you. Thank you very much. Lots to think about, and we'll talk about it as soon as we hear our next 2 panelists. The next panelist is Dr. Adam Moore, who is professor in the School of Information School at the University of Washington. where his work examines the ethical, legal, and policy issues surrounding intellectual property, privacy, freedom of speech, accountability, and information control. His talk today focuses on how AI systems can absorb stylistic patterns and reproduce a recognizable creative voice without copying any single text directly, and the implications of that. So Adam, thank you.
Start my timer so I try to stay on time here. Yeah, so this book I just had out came out February. Oh, a little bit closer. Yeah, so I should start by thanking everyone, thanking for the invitation, and great talk so far, and I'm looking forward to the discussions we're going to have the rest of the day. So this is a book came out in February, and at the end of it you can see I get into some thoughts about privacy, personality, AI, and intellectual property. It's all about intellectual property. And kind of what I was worrying about is some of the ways that AI can, or systems of AI can undermine intellectual property rights, but also how it might undermine privacy rights. See if I can use this. So a few cases, I'm not going to mention them, but you can see there's all, in terms of privacy, dignity, autonomy, sovereignty, if you will, lots of cases we could talk about. I get these from the AI incident database, if you're interested. It's got a lot of great stuff there, quite alarming. But each of these cases, there are factors related to privacy, dignity, and so on. So privacy, back in 2010, I had a book on moral and legal foundations of privacy, how you might define what privacy is, why we might think privacy is morally valuable. And I define privacy you might say a peculiar way, I don't know. It's a right to control access to and uses of certain kinds of places or locations, certain kinds of information. And I think it's important to make the distinction between access and uses of. And this is, I think, what we've given away is we say privacy is all about access. If I give you access, then automatically I've waived all downstream uses of control over that information. I want to resist that. When I have a doctor examine my knee, I am allowing access. I have not granted that physician the right to come and examine my knee whenever she wants. Right? If I give you some sensitive personal information about myself, maybe in confidence, I have not waived all downstream uses of and control over that. As soon as you adopt that rule, you see a lot of these problems that they're popping up now vanish, because I would have the right to stop these systems from using this stuff downstream. I've granted access, but I have not granted uses of beyond that access. So you got locational and physical privacy, informational privacy, and there's also another aspect, decisional privacy. We're used to this as well. Roe v. Wade, consenting adults in private places deciding what they do with their body, capacities and powers. And I would like to add in another area, personality rights, or we'll look at this at the end, publicity rights. It's kind of rights to reputation, or rights to control the look and feel of you as a person or as an artist, these kinds of things. I think it all falls under privacy if you view privacy as a kind of private property right in some sense. So there's some linkages there that I would want to lean on. I also like the idea of property because people like property, and it sets things in the right tone. So this case that pops up early on that I think about, and hopefully we can agree, this is a case where an artist, Kelly McKernan, is known for this picture on the right, and it's very stylistic. It took this artist a number of years to develop this style, market this style, get compensated, sell pieces of work, and then AI systems came along and copied it. And then she all of a sudden noticed that her commissions were dropping to zero, and people were selling versions of her work online or in print. So they said, create something in the style of Kelly McKernan. And this is a current case. Our lawyers in the room probably know, are familiar with it. So I think there's something ethically troubling with this case. We should all worry about it. The folks who developed these systems maybe didn't intend for this to happen, but they did allow or set up these systems to train on this specific style of work. The only way you get to what's on the left up there is by training, ingesting all the rest of her works. So you might, so I would start that as a base assumption, and work from that to this, in the sense that we should find this ethically troubling. So I want to turn to law. I worry I'm not a lawyer, but to help us here and see if we can find any way to justify these moral intuition about that something's gone awry in this case, and then see where we might grow. So this is what happens at the end of this book on intellectual property. It's more like what future work might be. So there is copyright law where we could talk about substantial similarity or striking similarity. Here we have a famous case in copyright law of someone who took a photograph and then somebody who did a tattoo. I think they got the law wrong in this case when they decided it, because they have an extrinsic test, the objective comparison of specific elements. So that's actual specific copying of certain things, versus the intrinsic test, which is what a reasonable audience would find the work substantially similar in total concept and feel. I think on that test, you can see how that would be true of the photograph and the tattoo, and also true of this AI fight between Brad Pitt and Tom Cruise, right? All not copied, none of it copied directly. It would not violate copyright, but may run afoul of this kind of total concept and feel. One way you might protect your IP or your private information is to infuse it with fake information, false information, so that you can catch the copiers. I don't know if that'll work against AI systems, but certainly we could do that with copyright. We can also take a look at trademark law, right? There's confusing similarity. Surely, if you think you're buying a piece of work from Kelly McKernan, right? And you buy something that looks, it's in the style of, you may be violating confusing area in trademark law. So so we might be able to expand that as well, or at least draw on some of that kind of material. But I think my favorite area of the law, where I think they actually get a lot of this right, is it flows out of a right to, one of the four torts of the right to privacy, the right of misappropriation. It turns into the right of publicity, mainly associated with famous people like Bette Midler or Johnny Carson. But there we get, in this case, where somebody sings in the style of Bette Midler, right? She sues and it ultimately wins in this case. They didn't copy anything about her, just somebody sang in her style. And she wins. I think it was a Ford Motor Car Cadillac commercial back in, I think it was decided in the 80s, late 80s. And there's another one, Here's Johnny, toilets and all that kind of thing. I think that there's room here. So there might be room in this area of law to say that we own parts of our style or personality. And we're going to use that to protect ourselves against AI in certain kinds of frameworks, in instances. Sure, I'm okay on time. Doing okay. So this is something I'm worrying about right now at the University of Washington. So we have something going on where we're taking our advising systems, where we actually have advisors advising students, and we're going to now start thinking about farming them out to AI chatbots, right? So you don't call anybody and say, hey, what do I take next term, or what am I going to do if I'm a physics major? The chatbot tells you, and then we're going to replace these people with AI versions of them. And what I'm worried about is that they're going to do this with me, especially with my online classes. So there I am over there with all this experience, all this stuff. And imagine you were to take an AI system, train it on what professors do in general, but then focus it in on exactly what I do in specifically everything I've ever written, everything I've quoted in a book or a text, so you know what I've read, and you create something, Adam Teaching Bot or whatever it would be. And rather than paying Adam a certain amount of money as a full professor, you pay a version, a bot of Adam to teach these classes. It may not be quite as good as Adam, let's hope it isn't, but it could be good enough to justify the huge savings they're going to have. We're already talking about this, and I think hopefully we can find that troubling. Because what's the AI system doing? It's copying things of value sometimes, and then packaging them up in a way, and then using those things of value against the person who created them and invested to create them and all of that. So here we get, that's why I actually had a schedule. This is cool. We can get some time back for questions. So I think there's some trouble here, and I want to run a Kantian argument on those creating these systems. Good old Immanuel Kant. And I did this when I testified in the Supreme Court, the state of Washington, several years ago about police sworn body cameras back in the day. And the idea is that the shortest version of Kantian moral theory that I can think up is the following. We're going to have an interaction, you and I, and you pick the principle on how we're going to interact, and it's going to be mirrored back at you. If you pick the principles of, say, justice and charity, being nice and so on, they're mirrored back at you, right? Yay. If you pick duplicity, cheating, violence, dishonesty, and they're mirrored back at you, you can't complain. Why? You picked the principle by which we interact. This is what I want to now deploy against those creating these systems of AI that allow these kinds of things to occur, like the Kelly McKernan case and, I don't know, the Adam teaching bot thing that's coming. So imagine we were to train these systems on, I don't know, CEOs of AI corporations developing AI, with the goal of replacing those CEOs or CFOs or programmers or mid-level managers or whatever. And maybe we're going to do it really sophisticated. We're going to develop a system and then look and see what you do in real life situations, and then fine tune the system so it gets pretty good. It's guessing really good. It's predictive analytics, downstream, all the cool stuff, right? And then we go to the people who own the company and say, let's fire the CEO, and we can pay this bot pennies on the dollar to do the same work, and the mid-level managers and the coders. Right? We can get rid of half of the company, most of the company. Right? So we have just used the principles that they themselves are infusing into these systems against them. I hope that these folks would say, I don't want to be treated that way, to create these kinds of values that are then harvested by an entity and then turned back against me. Those values wouldn't have existed but for my investment. And so that's the kind of argument I want to push. I haven't written that paper yet, but it's probably coming. So a tough case for me is a case of Greta Van Fleet. I don't know if you know this band. Would they exist but for Led Zeppelin? I don't know. But when first I heard them, I thought that's Led Zeppelin. It's a long missing Led Zeppelin song that I haven't heard. What's the difference between Greta Van Fleet and modern AI systems is those folks can actually play the instruments. They can actually sing. They can actually do all this stuff. They didn't just copy. So it wasn't like I'm in the Matrix movie and I hit a button and I download into my person the ability to play guitar, and I never actually sat around and learned how to play the guitar. That's what these AI systems are doing, right? They're not actually learning this stuff. So I'm a bit of an AI skeptic. Bells and whistles. They pretend to be something they're not, and they trick us. They don't understand meaning. They're probabilistic word generators or image generators, and we're tricked by that. We shouldn't be. So I do like Greta Van Fleet. I don't know if they would have existed but for Led Zeppelin, but they can at least actually play the instruments and actually be in real space. But I do think if we run our Kantian argument, and I don't know whether we do this with legislation or just on morality or certain kinds of arguments we would give, but we need to, I think to establish a right of personality, of style, of look and feel, codify that in the law, and then use that against these AI systems. And then back to the point on privacy, a right to control access to and uses of locations and information and perhaps style would stop it all in its tracks. So I'll stop there. Thanks.
Thank you. Very. Very thought-provoking. And our next speaker is from the other Washington, maybe came the furthest today. So we appreciate that. Mayu Tobin Miyagi is from EPIC, the Electronic Privacy Information Center, and she's a law fellow there in focusing on AI and human rights. And her talk today will be on workplace surveillance technologies. Thank you.
Hi. So I don't have slides today, but I don't know how to get this off. Sorry. Easy peasy. Okay. So yeah, my name is Mayu. I'm an attorney at Epic. We focus on privacy in all different sort of contexts, but today I want to talk about workplace surveillance, and it's sort of touching on how people can get paid for their labor, which is kind of what the previous talk was about, but I want to switch a little bit from large language models to just sort of kind of old school AI machine learning systems that are used to infer things about workers, such as their motivations, their productivity, their emotions, in ways that harm them. And I'm going to talk about 3 examples. One is surveillance wages, the second is productivity tracking, and the last one is anti-union surveillance. And they're all very important because, especially compared to consumer privacy, there isn't a ton of protections for workers, and there's, I think, a lot of opportunity. So there's a couple contexts that I wanted to set before getting into the examples. The first is that there is this pattern of blurring boundaries in terms of your work self and your private self, but that's not an accident. There's been years and years throughout US history of corporations trying to push for more control, more visibility into workers. And I think the barrier was more of a technological one, and now there's just a lot of AI systems that can track people, and it isn't something that happened by accident, I guess I should say. Companies have been pushing for this, and so that's sort of something that people get confused about, like, oh, it's just happening all of a sudden. No, it's been by design. And the second context is that workplace technologies can cause harm whether they're accurate or inaccurate. So obviously if it's inaccurate, it can mean that people are discriminated against, people aren't paid enough, or other bad inferences are made about them. But if it's accurate, it means that companies can know more about you without the employee having communicated that on their own, right? So that means there wasn't consent. Companies might know like exactly how much you're willing to get paid, like how desperate you are, and pay you less, even though you might be doing the same amount of work as someone else. So just wanted to set those 2 contexts before getting in. So the first example is surveillance wages. This is something that Vina Jabal has written really great work on, and we see it in a lot of platform sort of gig economy work, but it is expanding. So Vina Jabal's work focuses on Lyft and Uber drivers, and they talk about how the principle of getting paid the same amount for same kind of work is just out the window. So they're getting paid through an algorithm that determines how much they should get paid based on sort of what rides they've taken, when they're likely to accept a lower pay for a ride, demand, supply, etc. And another thing is that Lyft and Uber has been trying so hard to make sure that they're classified as contractors, which means that obviously you don't have to pay minimum wage, you don't have to get benefits, but the other thing is the employer can't tell a contractor where to go exactly, and so they're instituting these like game-like means to lure people, or I guess manipulate workers to go to locations that might be less lucrative for them, but Uber wants them there. And so some drivers have talked about like surges, saying that, you know, the app will say like, there's a surge in this area, there's more demand, and they go there and there actually isn't a surge. Or there's a bonus that says you're supposed to hit like 20 rides and then you get like a $200 bonus. But then they find that like, as it gets close to 20 rides, there's less and less rides and you're just kind of sitting there waiting. So you're working longer hours to sort of meet this lower threshold. And the real concern is that companies aren't really limited by any laws for doing this. It's not discriminatory to pay people different amounts for the same work unless it's discrimination on like the basis of race or other protected classes, where this is like largely unregulated. And yeah, I'll leave that there. The second kind of big category is productivity tracking, or bossware, people call them. Amazon is very infamous for this, for tracking workers, accumulating time off task. But some workers said, going to the bathroom, having a little chat with a coworker is counted against them. And some of them, skip bathroom breaks, or have found that because of the productivity tracking, they have higher and higher metrics to meet, and they're speeding up, and it increases their likelihood of injuries. Remote workers have also talked about their mouse movements are tracked, their keystrokes are logged. There are systems that take like screenshots and photos of them through the webcam like every 10 minutes. And it can affect your wages. So like if the camera captures you at the time when you're like grabbing water or going to the bathroom, it might say that you weren't productive for the 10 minutes and not count towards the number of hours you worked. And I think you guys could see, like, if you replicate it across all the employees, you're cutting 10 minutes from everyone's day, throughout, and it's just gonna add up to sort of like wage theft at scale. And so, again, that's another space where companies are being able to determine how to say someone is being productive, and it puts the burden on the worker to say, like, no, I was actually working, or work in ways that might be uncomfortable for them, but is sort of tracked as being productive. And so you're managing your work that you have to do, but also how you're being perceived and how you're showing that you're working, which adds to, the stress that workers experience, adds to sort of having a dignified work. And the last category is tracking union organizing. So, companies spend like hundreds of millions of dollars every year paying consultants to basically make sure that there aren't unions, successful unions. And it's hard to get concrete evidence of how they're tracking workers' sentiment. But there was one reporting from 2021 where consultants were hired for a union drive at 2 Seattle hospitals, and internal documents are showing that they collected data about rank and file employees. And this is a long list, but I wrote them down. They track their personality, temperament, motivations, ethnicity, family background, spouse's employment, finances, health issues, work ethic, job performance, disciplinary history, involvement in union activity, all to see who is likely to vote yes or no and how they can influence them to vote no on unions. And the union drive was unsuccessful. And so we know that employers can obviously use bossware to collect some of this information, but some of this come from external sources. We know that data brokers collect and sell these types of inferences about workers or anyone in general, and anyone can really buy them. And so, again, this creates this issue of workers don't have as much information as the employers. They can use that information about workers against them, and there really isn't a lot of regulations to stop this. And so it kind of creates this concern of the chilling effect that workers experience, and they're also not being benefited from being part of a union, which can increase their pay and improve their working conditions. Let's see where are we at. Okay, so I'll try to be quick. There's a couple things about the legal environment that allows this to happen. One of them is contractor classification, but in terms of data privacy, there's only 2 laws on data privacy that cover workers. One of them being California, and the other one is Illinois' Biometric Information Privacy Act, BIPA. And so those two cover workers, but the rest don't, and just kind of give a big exemption to employers. And so that's one big area that, is a space for opportunity. And at Epic, we always talk about data minimization as one way to achieve this. And so this is kind of going back to separating access to data versus how the data is being used. Data minimization says that data should only be collected for a legitimate purpose, and the collection should be reasonable and necessary to achieve that legitimate purpose. And so in the workplace context, there has to be ways to say employer can collect data for a certain use, but not be able to use it for other purposes like union busting or even like sell it to benefit from the inferences that can be made. And the last point I'll make is, this is a big opportunity for privacy people to engage with unions because unions create the space and sort of a countervailing power to say, the use of workplace technologies has to be negotiated through the collective bargaining agreement. And it also is an opportunity to understand how the technology actually impacts workers every single day. And obviously contracts come up every few years, so it's an opportunity to also experiment, learn, the shortcomings of certain protections or how it's worked, and be able to spread those learnings. Yeah, I'll stop there, and looking forward to your questions.
Great, thank you all. We have a lot to think about, a lot to work with. How about some questions? Justin will pass the mic around, or come to you with the mic. Start right here.
Thank you so much. Thanks for all the fascinating talks. My question is for Professor King. You talked about this way that we use LLMs, and we are not clear about how they are using our data to train. I'm coming from the startup background, where obviously we are using these LLMs. We have an AI product. I'm wondering, how can we basically manage this? And if we do not know how they use the data to train, what is our liability towards our customers, and how can we manage that?
Right. It's a great question. Can you hear it? Okay, it's on. I think the specifics, I'm not a lawyer, so I won't opine, but just to say more broadly, there's very little transparency, right? I think maybe there are questions about what liability you take on when you're using like an Anthropic-based model or an open source-based model for your business. I think a lot of the copyright cases we're seeing work their way through the courts don't impact you, it impacts those companies. But just to say, in California, we have AB 2013, which is a law I'm studying right now, that was supposed to help us understand kind of what are all the inputs, like what's the recipe essentially these companies are using. I would argue the law has been a complete failure, preview for my future paper. But I think it's a good question around what would be useful for us to understand for your perspective as a developer, me as a researcher, like if we know what's going into the training data, like I guess from a risk perspective, like what are you concerned about? And from a researcher perspective, like what am I concerned about in terms of understanding kind of the longer impacts of this data being in here? So I do think we need better transparency laws. The company pushback has been around trade secret. We can't possibly tell you what goes in here. But the thing is, we know largely what's in there in the sense that we know that they've scraped the internet as far as it could probably be scraped at this point. I think in some ways, the concern you may have might be more around the quality of the data that's been trained on. And for example, in future iterations, if they're excluding AI slop because it impacts the quality of those outputs. So there's just a lot of different dimensions that I think, and privacy is one of them, where being able to understand where did the data come from, what are the sources, what have you done to ensure that it is of high quality, it's not containing personal data. Those are all things that I would love to see, whether it's through regulation or through industry or through insurance, for example, is another venue where we might see like similar to cybersecurity insurance, AI insurers start to demand information around those things. But I do think we need just greater transparency. So for example, as a developer. Yeah.
We capture business data.
Yeah.
And we give it to LLM to analyze it so that we can answer questions.
Sure.
So when we don't know how they use the data.
Right. Well, I think in general, if you're an enterprise customer, hopefully your own attorneys have looked at your contract. I think in most cases, they're not training on that data. But, I wouldn't assume you need to know. I mean, I think if you look at Amazon and the issues that have come up with Amazon and all of their many businesses that do work on marketplace and the issues that have come up from Amazon potentially using people's own business data against them to create their own products and undersell them. Yeah, I would be concerned, but I mean, maybe the difference there is that it's a platform versus you're incorporating a model, into your own business platform. But again, not a lawyer. Those are just the things I would be concerned about, though.
Great. Other questions? Sorry. Other questions? Back. Great, Gareth. Justin will be there in a second.
Thanks. Thanks for a great panel. I have a question also for Dr. King, sort of about the relationship of the kind of increasing function. Here, I'll stand up so that you can see me. The relationship of the kind of growing integration of AI tools into our data that wasn't necessarily the case, even a couple of years ago when you're mostly just interacting with the chat interface. I'm one of those people who always goes in and turns off the training right away. But recently I've noticed that tools like Gemini are starting to link certain kinds of functionality with a willingness to release data. So you can't have it be aware of like older chats, which is really very useful, if you're using these tools. And likewise, if you want to sort of open it up to your full sort of Google Workspace or, Suite to be able to look at everything that you've got, that comes with additional compromises. So it made me think, is there an inverse relationship between effective privacy and the direction these tools are going, where they get more and more integrated into all your data and your history and all that kind of thing?
Yeah, I think it's a great question. And I think there's kind of two perspectives you could take. One is the maybe pro-company view of like, well, they're much more useful when we have everything, which may or may not be true. I also think there's a very strategic decision, and we've seen that over the past few years in terms of antitrust, when, for example, regulators were looking at Meta and their acquisition of WhatsApp and Instagram, where those were three separate companies, and suddenly it became a huge priority for Meta to suddenly put them all in the same kind of internal infrastructure, because then it became much harder to uncouple them. So I think it's a product design choice, and I think it's going to be one of the hardest things that makes data minimization, which Mayu mentioned earlier, which is a data protection principle. It's going to be one of the hardest things to wrangle in that space, because I think the companies have gotten very smart about both, again, maybe a legitimate argument that, yeah, they're much better when they have access to everything, but also, how do we practice data minimization when we claim we need access to everything and it makes it better? And I think Google is the area where you're seeing this actively the most right now, where suddenly your Google Docs, potentially, if you're just a free user of Google, all these different kind of spaces that were maybe somewhat connected, but not like deeply connected, are increasingly becoming deeply connected. And yeah, how do we prevent that from happening if we don't want it to? I mean, I think the thing I would come back to in the privacy space is that you should have the ability to be able to say, I don't want this. I would prefer not to have this happen. But it is in their best interest, I think, to force that issue and to make these things deeply embedded within each other. So I don't have the most optimistic point to leave that on. Otherwise, I do think we're going to continue to see this play out with more frequency as time goes on.
Yeah, go ahead. You want to get in? Yeah.
I'm not a lawyer either, but I do remember a case called FTC versus Wyndham Hotels, where Wyndham was caught in violation of basically holding more information than they should have been holding, and they got hacked and so on, and the people who got hacked could show harm. Is that something that could help in this space?
Oh, in terms of data minimization, I can't weigh in on the legal. I'll just talk about maybe the conceptual, where, yeah, it might be that where we start to see some of the hiccups. I mean, I'll go back in time actually to Google Buzz, which most of you probably have never heard of. Has anybody heard of Google Buzz? Of course, Mike has heard of Google Buzz, yes. I hope you would have, and Ryan. That was actually, I think, kind of an interesting 2010 example of what we're talking about, where that was Google's very first chat product. It had a very short life. Because they released it, they had only been using it internally, worked great as a workplace tool, put it out into the world, and suddenly people's chats, where it was integrated into Gmail, and it pulled in your entire Gmail contact list. So there's very publicized examples of like women whose abusive husbands were like getting Google Buzz notifications about what they were doing, and people who had like used it for work or used their Gmail accounts for work, basically collapsing those boundaries that people had set up, and they had to pull it, and they were actually sued, I think, by the FTC. We'll probably see examples of that come up, because when these systems are designed to take everything in, inevitably you're going to cross these boundaries that some people are going to be very unhappy with, and so I think it becomes more of a consumer pushback of, I actually don't want you in my calendar, or I don't want you in my phone book, because you don't have it all figured out. Like, you're suggesting things to me that I'm completely unhappy with. So that's probably in the short term where we might see these, basically big screw ups that the companies make because the technology is not perfect, and they end up crossing these lines that people don't want them to.
We have a question here in the front and the back. We have about 5 more minutes.
Hello. Thank you so much for the talks. Okay. This question is for anyone who has an opinion. But I think we're definitely approaching a time where there's a growing number of users who are of the opinion that, the benefits of like these AI and like these chatbots outweigh like privacy concerns. And they're like, as long as it's doing what I need it to do, they can use my information. Just how do you feel about, I guess, like the dangers of this mindset and people who might be pushing for privacy, but there's negating views and the legal aspect and stuff like that.
So before you answer that, let's have the second question. We can just hear the 2 questions and then we can answer them.
Thank you. I'd also address my questions generally.
Can you speak into the mic more?
Oh, okay. I guess it's a bit of a shotgun mic. So I'd address my question generally. How do we see the gathering, accumulation of protected data and kind of the dialogue around protection laws like GDPR and the most recent information from China that protects personal information when that information is used in data training sets, where there has to be very specific justification and term limits on how long individual data can be retained?
Thank you. Maya, you want to start?
Oh, I can't take that. Yeah, I guess I'll try to address the first question. I'm not as familiar with the second question, but yeah, I would say, well, one, I think the principle of data minimization is supposed to help people who say, I want this product, or some things are useful to me, but I'm still worried about privacy. Like, you should be able to have both, and you shouldn't have to like say, oh, I can't use this product that's useful to me because there's privacy concerns, right? Like, the ideal is that you get the usefulness. But I guess I am concerned about people who sort of use AI systems in ways that, like studies show, there's a lot of cognitive offloading, and I do worry about, students who might not be learning as well as they should be from human instructors, and I think it is often used as a way of like cost cutting and undermining teachers, even when teachers should just get paid more and we should invest in education. So yeah, I think that is a concern, but I'm not one to say, like, if something is useful to you and you know how to use it, like, you shouldn't use it because of privacy concerns. I think we should all fight for the privacy rights too.
Well, I'll speak to the first question as well, not so much as this. It reminds me of the great, I don't know who coined the term, the great privacy giveaway, where folks are more likely to trade privacy for the shiny bells and whistles that are right there before them on the page or the chatbot or whatever. And I think I push back on that with my students in the following way. So whatever area of expertise maybe you're training in or you already have, start asking these systems questions within that area of expertise. For me, it'd be political philosophy and ethics and whatnot. And what you'll find is that it's incredibly average and or below average stuff that it's spitting out at you. Why? Because all the stuff that is scraping in, think about the information pollution out there in the world. How 25,000 articles, I did some work on this. How much stuff is this being produced? Much of it is junk, all being scraped in, all being part of the output to you. So when you focus AI and on the areas where you're an expert, you're going to find that this stuff is very weak, and for my part, almost never useful, unless it's like write an email for me or something like that. But when you go outside of your area of expertise to some other area, maybe it's an area of law I don't know or something like that. Wow, it looks great. It's amazing, right? Only because I'm not an expert in that area. And so as soon as your students start to realize that, it's this mindless, purposeless thing that predicts the next string. And if you're an expert, you're going to realize very quickly it's not doing you any benefits, and also cognitive offloading and whatnot. So.
100%. And just to say very quickly that we're still at the very beginning stages of this. OpenAI, I just got the email from OpenAI last week. Product recommendations, like the world of consumer shopping and these tools and advertising is just starting to roll out. And I think that's where you'll see a lot more of this overlap. Maybe it'll be helpful to people, and maybe it'll be disconcerting, depending on how it rolls out.
I'll ask my colleagues should we have a couple more questions, or we have a little time? One more. I saw your hand.
I'm seeing more books that are recently published that have caveats in there that says this book may not be used in any way for training an LLM. Are there any teeth behind that, or is that just a recognition it's going to happen anyway and saying, keep your hands off?
It's like that notice people type into Facebook. Facebook may not use any of my... The IP or the lawyer have anything?
I know, I'm looking at that. Well, I'll add, I don't know if it has teeth. Like, I think not having that statement shouldn't mean that you agreed to the LLM training it, but I think it is interesting. Like, maybe it will add to the evidence, but I'm not sure. I think we're gonna find out.
I know many of us have probably gotten this notice in the last couple of months, where if your works have been used in training AI systems, or you're part of a class action lawsuit, and you might get up to $3,500 per book or whatever.
Yeah.
I'm like all in on that.
I want to thank our colleagues for such a provocative and interesting panel, and they'll be around today, and you can talk with them at length if you'd like. And now we have a lunch break. And do you want to say anything, Ariella, about?
We have a lunch break, so we're going to be here at 1 o'clock. So thank you, everyone. And thank you, Carol.
Thank you.